Hello, everyone. My name is Mohammed Salyani, and welcome to Wilkin and Guttenplan's quarterly webinar for Common Interest Realty Associations. Our topic today is how to run effective community association elections. And we have two speakers here. We have Matthew Earle and we have David Schwartz. Before we move on, I'd like to go through some housekeeping rules for you. To ask a question, please use the questions pane in the GoToWebinar dashboard on your screen. We will try to answer as many questions as possible. This webinar is being recorded and will be uploaded onto our website at www.wgcpas.com. Additionally, a scanned version of the webinar will be emailed to all you attendees. We will be sending a seminar survey after our webinar survey after the webinar. Please fill it in and send it back to us. We really value your comments. All right, before we move on to the actual webinar, we'd like to go through a polling question. How many of you have faced challenges during your election process? Please vote now. Wow, we have 100% saying that yes, they have. So this is definitely the right place to be. All right, I'm going to introduce our first speaker for today. Matthew Earle is a partner at the law firm of Cates, Nussman, Rapone, Ellis, and Farhi. It is in Hackensack, New Jersey. He concentrates his practice in the areas of community association law, land use, real estate tax appeals, international law, general equity, and commercial litigation before state and federal courts of New Jersey and New York. Mr. Earle has extensive experience acting as general counsel to community associations and providing legal services relating to, among other things, assisting with transition from developer to owner control, review and amendment to governing documents, preparation of rules and other corporate documents, managing association risk, resolving insurance coverage issues, assisting with compliance with federal and state laws, advising boards on fiduciary duties, dealing with resident disputes, handling annual meetings and election issues. Mr. Earle is also experienced in all facets of litigation impacting on community associations, including construction defects, election contests, convent enforcement, and collections. Okay, take it away, Mr. Earle.
All right, thank you very much, Mohammed. Just to give you guys an overview, what I want to do is go through the election process with you. And as we hit certain points where I think we could really flesh out problems that I've seen in my practice, and we'll go over those in more detail. So I think the first thing to talk about is what's your goal in running an election. I think it goes without saying that the obvious goal is to have a fair, free, and impartial election conducted in accordance with the law and the governing documents. You know, in both New York and New Jersey have statutes which govern the conduct of corporate affairs. In New Jersey, you have the Nonprofit Corporation Act or the For-Profit Corporation Act, depending on whether you're a condominium or co-op and how it's organized. In New York, you have the Business Corporations Law. And so you know the statutes are very, very similar. So I'm going to be speaking generally about New Jersey law, but in fact, they have almost the exact same substantive law. And just the same as Delaware and most of the states in the country, they've all modeled their statutes on each other. And what are your governing documents? Well, if you're a condo, your governing documents are your master deed or your declaration, your bylaws, and your certificate of incorporation. If you're a co-op, you'd look to your proprietary lease, your bylaws, and your certificate of incorporation. Your other goal is to enfranchise as many voters as possible. You want to count any ballot that's been validly cast. You don't want to disqualify ballots for non-substantive reasons. You want to reach a final result quickly and have a firm result. You don't want the election to drag on for weeks while votes are counted and challenges are heard and that kind of thing. You want to get it over with because you need to have a board in, you need to conduct your business. You want to discourage election challenges. You know, you don't want to have questionable procedures that leaves the door open to lawsuits or things like that. And, you know, if you are challenged, and it does happen, unfortunately, you want to be able to win that challenge.
Matt, do you have an example of an election you were involved in that withstood a challenge?
Yeah, there's been two recently. One where there was accusations of some technical defects in the election. Now, to talk about that, I'll talk about it generally. Generally, you want to stay away from technical defects because it does open the door. But in general, when you look at the statutes, and we'll talk more about this later, that relate to challenging an election, they talk about, it gives the court broad authority, and the way the courts are going to exercise that authority is they're going to look for substance over form. So that, in that case, the election withstood the challenge. In another case, we had a situation where the board was sued for not holding an election in a timely fashion, and we happened to withstand that challenge because they had scheduled the election. So we'll talk more about those statutes later on too, but we have experienced that.
Okay.
All right. So just some basic principles. I talked about the first bullet already, about how your association is organized. When you're looking and preparing for an election, you're really going to look at the portions of the statutes that deal with meetings of members. And you're also going to be looking at your bylaws and as it relates to elections and meetings of members. You have to have an annual meeting each year. It's a legal requirement. You know, in some cases you can have a meeting every other year, but for our purposes in condos and co-ops, you need to have an annual meeting every single year. If you do not have a quorum at a meeting, you shouldn't just give up. You need to adjourn that meeting and seek to have another meeting and encourage people to come out to vote, and you want to keep doing that until you reach a quorum. And if you don't reach a quorum, then we'll talk about the consequences of that later. The other thing I want to point out is I think as a general principle, you should be attempting to strictly observe the requirements found in the statute and governing documents. And I'm going to put emphasis on technical compliance here, and the reason why is there's no reason not to be technically compliant. It just opens the door. So to the extent that you have a choice to say, well, I could just have this type of proxy or that type of proxy, and the other one is technically compliant and the other one isn't, it may not result in an invalidation of the election, but why take the risk? Why take a chance? Now, there are certain provisions that, if not followed strictly, will result in your meeting being thrown out. For example, if your meeting has to be noticed between 60 days and 10 days prior to the meeting, and you don't meet those guidelines, then there's a very good chance that a judge would invalidate that meeting. Or, you know, so that's something you have to be very careful of. Another point, and we just had an election contest that related to this, the board should be careful and not exceed in its authority in drafting election rules, setting deadlines, imposing requirements that go beyond what it's specifically authorized to do in the document. Now, as a general principle, the board has authority to administer an election. There's a case called Verna v. the Lynx in New Jersey, which talk about the board's authority. And, you know, the board has the right to prepare the notices, send out the notices, have an inspector of election, appoint an inspector of election, and do what's necessary to govern the election. But if it goes beyond that and starts getting involved in the politics of the election as a board, those acts may be considered to be ultra-virus, meaning beyond its authority. Now, in the case Verna v. Lynx, the board in that case conducted a quote-unquote candidate audit, which was not authorized by the bylaws, and in fact said one candidate was not in good standing, which happened to not be the case, and the court said that that act was ultra-virus and may have resulted in the invalidation of the election. So there's we'll talk about later, but there's a couple areas where boards often run into this issue, which is, for example, setting a deadline for when people have to declare their candidacy or be nominated as a candidate. Unless you have that authority in the documents, you may have a real issue in doing that. Or deadlines to submit proxies. Generally, legally speaking, proxies should be accepted up until the close of the ballots, and if that's the close of the polls. And if you set artificial deadlines and don't count proxies that have been cast, you may run into a problem. And I think, and I'm not doing this just to drum up business, but I think that at least from time to time, you need to obtain professional assistance to prepare for the election, to review your forms, your notice of meeting, and all the other forms we're going to talk about, and make sure that you're in compliance with law. One other thing, which is important and critical to me, is, a lot of our clients have been condominiums and co-ops for 30 or 40 years. Elections have been conducted in a particular way for that time period. traditions and things like that have developed. Don't put blinders on with that. Just because you've done something a particular way for a long time doesn't mean you're doing it the right way, and it doesn't mean that a court will uphold it in the event of a challenge.
Matt, do you face resistance from boards when you tell them to change what they're doing? And what do you say to them to try and convince them?
Well, that's a great question. And we do receive resistance, not so much from the board, the directors themselves, but oftentimes from people in the community. You say, especially when you're coming in as counsel for, it's new, it's your first election, and you want to do things the way that you think they should be done, and you get resistance from owners. Well, we've done it this way for this many years, and the board will then give us resistance because they're getting political pressure. And what I tell them is, ultimately the choice is the board's, but why take the chance? And people will get used to it very quickly. Maybe the first election they won't like it, but then, once you get through and they see how smoothly the process goes, people will come around.
That's a great answer.
So just to go over the timeline briefly, and this is not a mandatory type of timeline, but generally, first you want to send out a notice asking for candidates to nominate themselves or to be nominated. And you want to give them a deadline. It's not a hard deadline. People could still be nominated up until the meeting. They can be nominated from the floor at the meeting. But it's a deadline to say, if you give us your name by this date, we're going to send out the notice and the courtesy form of proxy with your name on it, and you'll be in the running in that manner. It's not mandatory to do this, but most associations do it. It's a way to make things run orderly. Generally, the board wants to appoint inspectors of election, and we'll talk more about those a little bit, but I strongly recommend it. It's not necessarily mandatory. Your documents may require it, but it's something that you should do. And you may want to think about conducting a candidates night, especially if it's a contested election, to give people a forum, the candidates a forum to voice their positions and to give owners a chance to ask questions. If you had a very contentious election, you may want to consider having your candidates night moderate. Some of our clients, we moderate or we bring in a third party to moderate, and you might have a format where each candidate gets a particular number of time. They get a particular amount of time to answer written questions that are presented and things like that to make sure that each candidate has the exact same platform.
Matt, I have a question that came in. One of our listeners has asked that the proxies that we utilize grant the owner the opportunity to utilize a board member to act on their behalf. Of course, it cannot be a board member who is running for election, but is that acceptable to allow a board member to be utilized as the proxy voter?
Well, that's a good question, and we'll talk more on this later, but proxies and ballots are two different things. So we're going to focus on the proxy. A proxy is a document that gives someone else the right to cast your vote. That can be anybody. It can even be a candidate who's running in the election. It's not uncommon for a candidate to have proxies where they're naming themselves as proxy. Generally speaking, there's two types of proxies. There's a directed proxy and a general proxy. A general proxy says, I'm giving my vote to so-and-so to cast as they deem fit. A directed proxy says, I'm telling them how to vote. And so generally, if we do a courtesy proxy, we always use the directed proxy form. And it's customary to name a board member as the default proxy holder, leaving open the option to appoint someone else as proxy holder. And the reason why you do that is really just a practical thing, that you know that board member is going to be at the meeting, because the proxy holder has to physically attend the meeting and quote-unquote cast the ballots for those proxies to be validly counted. If the proxy holder is someone who doesn't show up, then you can't count the proxy.
Okay.
So to go on with this, then you have the time when you have to send the official notice of meeting within the required legal time frames. That's mandatory. You have to send the notice of meeting that sets forth the time, place, and purpose of the meeting. And usually it's between 10 and 90 days. Some documents have it 10 and 60 days, but generally it's somewhere. Some have it 10 and 30 days. So it's generally somewhere within that time period. You have to strictly abide by that, like I mentioned earlier. You'll have a courtesy form of proxy. You don't have to do that, but it's strongly recommended. If you don't have a courtesy form of proxy, you might have trouble getting a quorum. You need to have a membership list that's prepared prior to the meeting, knowing who's in good standing and who are the owners of record, and talk a little bit more about that. But there's a concept called the record date. People who are owners and members of the corporation as of the quote-unquote record date are entitled to vote. So there's a default statutory provision which says the record date is the date prior to the day on which you mail the notice of meeting. Generally, that's the date that we use unless the board, for some reason, sets a different date. So then you have to have written ballots for the meeting. Generally, if you've appointed inspectors, you need to sign the oath of inspector, and you want to have an agenda usually. And then you'll have your meeting, and you'll count the votes and announce the winners. So let's talk a little bit about candidates. Generally, the law only requires that candidates or directors be at least 18 years of age, but additional requirements can be set forth in your bylaws, which may say they have to be a shareholder. If you're a co-op, they have to be a unit owner if you're a condo. It may have a different age requirement. It may have a good standing requirement, but the candidate requirement has to be in your documents somewhere. The board does not have the authority to decide its own candidate requirements. They need to be in the documents. Another important point is that, at least in New Jersey under the Nonprofit Corporations Act, any restrictions on nominations must be in the bylaws adopted by in a bylaw adopted by the members, meaning a bylaw that the members, the unit owners, voted on. So if you say that candidates need to get 50 signatures on a petition to be a candidate, that has to be in your bylaws or it's invalid. And like I mentioned before, nominations should remain open up until the call of nominations from the floor at the annual meeting. I think that if you said you have to be nominated at least a month in advance, and someone tried to be nominated later on, I think you run a real risk of if you don't let that person run. This is an important thing. We could spend a whole day on this case. The New Jersey Supreme Court recently decided a case called Dublier v. 2000 Linwood Avenue Owners Corp. And in that case, the board of directors had adopted a rule which prevented shareholders from putting any written campaign materials under doors or in the building. And what the New Jersey Supreme Court held, and I'm going to summarize here, what they held is that a board can't overly restrict free speech, especially when it's something that's compelling and that relates to the governance of the association. And I think this case, it was about a co-op. I'm sure it applies to condos. It'll apply to community associations. We have the same general principles at play. And so what that means is that the board has to give a candidate or anyone in a co-op or condo or community association election an adequate means and methods of distributing political speech. And so in that case, the court said, look, if candidates or supporters want to put things under doors, the board can't restrict that. They can't stop it completely. They can put in reasonable restrictions. Maybe you could put in a limit on the number of communications. So instead of putting out 50 flyers every day, maybe it's one flyer a week, or maybe a total number of flyers. They said you could maybe put in restrictions about the time of day. So you could have, only flyers distributed during certain hours, or only someone in the lobby asking for votes during certain hours. You may be able to put in reasonable restrictions, but you certainly can't put in any blanket restrictions. And one of the other things which is important about that case and why lawyers don't like the case is it's a bad case, because the facts in that case were strange in that the board restricted candidates from putting out flyers, but the board was putting out its own flyers. And I think that would understandably rub anyone the wrong way. But the general principle here is it's a political campaign. People are allowed to get out their message. And, you'd have to take a close look at your rules and regulations to see how they, that relate to this distribution of materials in the building, to see how it relates to the case. We've mentioned candidates night and it being moderated earlier, so I'll skip over that one. Again, this goes back to the Verna case, the second bullet point. The directors can campaign in their unofficial capacities, but that they should not be, well, this says directors are free to campaign in their official. It should say unofficial capacities. But you can't campaign with in your official board capacity. You can't use board resources and things like that, or that may be ultra-virus acts, which could subject the election to challenge. Notice of meeting, I mentioned it has to be mailed within a certain time frame. We talked about the record date earlier. One of the things you want to do is have an affidavit of mailing prepared by your manager or your secretary or whoever does the mailing, to have that record that it was mailed on a particular date, so that you can present that at the annual meeting as proof of notice of mailing. I've included a sample notice of meeting form that sets forth the type of form that we might use in a particular association. This is a sample affidavit of mailing, pretty straightforward. I'm going to talk a little bit about a proxy. Like I mentioned, a proxy is different from a ballot. A ballot is cast on the night of the meeting. A proxy gives someone else the right to cast the ballot on your behalf. All New Jersey law requires is that a proxy be in writing and signed by the member of the shareholder who is the one owning the proxy or owning the vote. I don't think a board can dictate a form of proxy. I don't think it's permissible. Certainly I've seen it, and maybe it would pass muster, but I don't think so. I think that if something's in writing and it's signed by the person and it reasonably says, I'm granting this person the right to cast my vote, I think it has to be accepted. And in fact, there's cases in New Jersey saying that even if the bylaws gave the board an authority to dictate the form of proxy, that may not be sustainable. So if you do send out a proxy, which I encourage, I think you want to call it a courtesy proxy to indicate that it's not mandatory. And talked about this earlier, the form of proxy should make the proxy holder a person who the board knows will attend the meeting, but it should leave space for someone to designate someone else if they don't like that person. So you have a contentious election, and you make the board secretary the default proxy holder, and that person's not running, but it's contentious. Some people may not trust the board secretary. They might want to write in someone else to be the proxy holder, which is fine, but that person has to then attend the meeting for it to be a valid proxy, which I say in this bullet point. One thing that's very important, especially in New Jersey, is a proxy is not the same thing as a ballot by mail. In New Jersey, a ballot by mail has to be specifically authorized by the governing document. So a ballot by mail, you might call it an absentee vote. It's just people, they send in their votes, and they don't need to name a proxy or do anything like that. Again, a proxy is different. It gives someone else the right to cast your vote at the meeting. So if you're not naming the default proxy holder, you're naming John Smith. John Smith has to go to the meeting and actually cast the ballot for that to be a valid proxy. We talked a little bit about directed proxies versus general proxies. We like directed proxies. It I think, removes opportunity for there to be shenanigans or for someone to say, here, give me your proxy and I'm going to vote for John Doe, and then they don't vote for John Doe and people are upset by it. So a directed proxy looks like a ballot. You check off who you want, and that requires your proxy holder to vote in that manner. They don't have any discretion on how to vote. Here's a form of a courtesy directed proxy. And you see there's a line if you want to appoint someone else as your default proxy holder. Inspectors of election. We strongly encourage the board to appoint inspectors of election. There's no particular requirement on who the inspector is, except that it can't be a candidate. Anyone else could be an inspector, so it could be your property manager. It can be your some unit owner or shareholder who's willing to volunteer. But if you appoint an inspector, it gives them certain legal responsibilities and legal authority to rule on the validity of proxies that are cast, to rule on which owners are eligible to vote, and I think it takes the election out of the board's hands and puts it in the hands of someone else, and that insulates the board from accusations of wrongdoing or anything like that. So we really like to have inspectors, and inspectors are legally required to take an oath, and an oath just says, I will perform my duties as inspector with strict impartiality according to my best of my abilities. That's the oath that an inspector takes. They will do a report at the end of the election and certify the results of the election.
So, Matt, after the election, who should keep the ballots and for how long?
Well, it's a good question. I think it depends on who your inspector is, and we'll talk a little bit later about in a contentious election you might want to have a third party do it. But generally, who should keep the ballots? I either like to see the association general counsel keep the ballots or the association inspector if it's an independent third party. And I think the ballots should be kept for, at the minimum, the length of the terms of those people who were elected as directors. So if you had people elected for 3-year terms, I think you better be keeping them for 3 years. And the reason why I say that is in New Jersey, the case that we talked about earlier, Vernon v. Links, says that, while an election challenge should be brought as soon as reasonably possible after the election, it may be the case that as long as those terms are in play, there may still be an election challenge at some point. So until that becomes moot and those directors are no longer on the board, I would keep the election material.
Okay.
So then you have your night of the annual meeting. You want to have an agenda. Most bylaws will have an agenda in there, whether it's calling the roll and certifying the proxies and having reports of officers. Generally, we like to follow that, but it's not crucial. I mean, if you don't follow it, there's no penalty for it. I think you should announce when the polls are opening and when they're going to be closed. You should have written ballots. Ballots should be counted by the inspectors when the polls are closed, and they should have legal counsel available if there's questions about any of the ballots. So sometimes you'll get a situation where you have 3 board positions available, and someone checks 4 boxes. What do you do? Well, you can ask the attorney. I would probably say you can't count the ballot because how do you know which 3 should you give it to? Who gets excluded? So that gets disqualified. You need to have a list of members, your list of members available at the meeting. I've never seen it come up, but the law does say that if the list of members is not available, the meeting has to be adjourned upon the request of a member. So make sure your manager brings that list of unit owners or shareholders to the meeting. Here's a form of ballot, very similar to the proxy, except you call it ballot and you don't need to appoint a proxy. Here's an important point, eligibility to vote. We talked about the record date earlier. Only those who are owners of record as of the record date can vote. Many associations and co-ops have a good standing provision in the document. If you don't have that, then you can't disqualify people for not paying maintenance. But if you do have a good standing provision, then people may be disqualified for not paying maintenance. I think that one issue that comes up a lot, that we see a lot, is, well, why do we want to disqualify people who only owe $25? The board sets a cutoff, and they say, well, we're only disqualifying people who owe $100. I don't think you have the authority as a board to do that. I think you have to disqualify those people. One alternative to disqualifying all those people may be a minimal, debt forgiveness. So anyone under $25, the board actually wipes those off the books prior to the election, and whatever date you use to determine good standing, so that you're not disqualifying people for $1 or 25 cents. But in the absence of doing that, I think that you can't arbitrarily set a cutoff on the good standing.
But Matt, what happens if the association's documents are not clear as far as good standing?
Well, it's a good question. I think you'd have to give that to legal counsel and have them give you an opinion. But the way I would generally come down on that is, assuming it's really not clear, you have to interpret it in a way I think that will enfranchise the greatest number of people. I think when you're looking at elections, the courts are going to view these liberally. If there's a doubt about whether John Doe is in good standing or not, I think the court is going to come down on the side of good standing, because the point of these elections is to let as many owners vote as possible as to who is going to be governing them. Excuse me. One issue that comes up all the time is ballot confidentiality and anonymity. So obviously, I think if you're a voter, you don't want people to know who you voted for. You don't want the board to give you a reprisal and retaliate against you because you didn't vote for them, or you don't want to be confronted. You want to have a secret vote. At the same time, there's a couple of reasons why you don't want to have a secret vote. One is it may be impossible. If you are voting based on your percentage interest, or if you're voting based on your number of shares, it may be very difficult to set up a voting scheme where you could then anonymously cast a ballot. And the other reason why it's difficult is that if there was an election challenge, and, for example, it comes down to one vote, it's the closest election in history, it comes down to one vote or 2 votes, and the board and someone says, these 2 people were not in good standing. And the court says, yeah, you know what, they weren't. Which ballots do you disqualify? You don't know who voted for who. And you throw the whole election in disarray, and maybe it becomes invalidated, where if you had a way to track who voted for who, you may not have that problem. So what I generally try to do and encourage people to do is to not have a blind voting system where you just put a blank ballot in a box and no one knows who it goes to. I like to have some type of tracking system, and I don't like to disclose that to the board. And I wouldn't, and I don't disclose it to owners, but there has to be a way at the end of the day to figure out who voted for who. And as a matter of fact, there's cases out of New York stating that a shareholder may have the right to review ballots as part of a right to access corporate records. So I don't think you can reasonably have an expectation that no one will ever know who you voted for. But I think you can set up a scheme to insulate at least the board and management and so on from knowing who voted for who, and limit that as much as possible. Talk a little bit about election challenges. There's two primary types. The first type is failure to hold a meeting. So this is what happens. The board doesn't want to have a meeting because it doesn't want to deal with it, or you don't get a quorum and you try another time, you don't get a quorum and you give up. Well, any shareholder who's aggrieved by that can then go to court. And if you don't have the annual meeting within 30 days of the date that's required in the bylaws, or within 13 months of your last annual meeting, the court can then order the meeting. And the court, in fact, pretty much has to order the meeting, with very few exceptions. It's a right of a shareholder to have the annual meeting. And if the court does happen to order the meeting, then they set a meeting and there's no quorum requirement. So the answer to that question previously, what happens when you just can't get a quorum? Mm-hmm. Well, you don't have to have the meeting. You go on with business, but if someone were to challenge that and go to court, the court will order there to be a meeting, and there won't be any quorum requirement. Another type of election challenge is a challenge based on the procedures or some type of fraud. The court can review it, and the court will do whatever justice requires, will grant whatever relief justice may require. The court has very broad, equitable authority and power to review an election. If you are thinking about filing one of these lawsuits, you want to do it as soon as possible after the election. If you wait 2 years, the people who are on the board may have already had another election, and it's moot. The longer you wait, I think the less favorably courts look upon those kind of challenges. And I don't think it's easy to win an election challenge. We've done a couple where we've been plaintiffs. We did one where there was ballots that were shredded. That was an easier one. There's been one based on procedural defects, which were less easy. But it is out there, and I think that the real problem for a board in dealing with an election challenge isn't necessarily losing the challenge. It's having to deal with the legal fees. It's having to deal with the stress, and instead of dealing with legal fees, having to deal with it on your insurance loss run. So if you tighten your procedures up and you have a good counting process, then you can probably avoid those problems and avoid any type of challenge. Now, here we go. We have a difficult election. It's hotly contested. A lot of accusations back and forth about the board is corrupt. They're having their attorney involved, and the attorney always takes the side of the board. He's a bad guy. What do we do? Well, one good way to tamp down election controversy is to bring in an outside person who's not affiliated with the day-to-day operations of the board to act as an inspector of election, and maybe even to conduct the entire election. You could have a public accountant, a CPA. You could have an attorney, a third-party law firm. You can have an independent election company, and they can all be used either to run the whole thing or to run various portions of it. A lot of times that will really take the teeth out of, the board and its management and their attorneys are the ones counting the ballots, and they can't be trusted, and they're against this. It'll take the teeth out of that. The downside, of course, is there's going to be a cost. None of those people are going to do that for free, so you're going to have to pay that money. But I would point out that successfully killing a challenge before it started is going to be a lot cheaper than dealing with one after the fact. Next thing I'm going to harp on, don't make past mistakes. Just because you've done something for the last 20 or 30 or 40 years does not mean it's right. Does not mean the court will validate that if it's challenged. Err on the side of counting votes. And this is a real important issue. We've had election controversies that related to bad language in the governing documents. And in fact, as the attorney, it was impossible for us to resolve because the language was either so ambiguous or so bizarre that you couldn't make heads or tails of it, or you couldn't run an effective election. I know that it's difficult usually to change bylaws and provisions like that because you need to get a vote of the owners together. But it may save you a lot of headaches down the road if you can make those changes and fix it. Just going to talk very briefly about New York law. Like I mentioned, New York law, Delaware law, New Jersey law, the statutory provisions are for the most part, almost identical. One thing that is different in New York is when you challenge an election, it's called an Article 78 proceeding. And the statute of limitations on that is 4 months. So in New Jersey, there's no hard and fast statute of limitations. In New York, you know, if you have an election, you get 4 months past it, then you're in the clear.
All right. Matt, I have a couple of questions here. I think the first one is possibly a little easy. Can only owners run for elections of trustees?
Well, that's going to depend on what your documents say. Just by law, anyone can be a trustee as long as they're over 18. But most documents have some requirement that a director be a shareholder or a unit owner.
Okay. So I guess it wasn't as easy as I thought. The next question is, if they have ballots in envelopes, should the envelopes be opened only at the meeting, or can they be opened prior to the meeting?
Yeah, it's a good question. I think that the way I would answer it is this way. Unless you're doing a ballot by mail and you're not even having a meeting, then there's not going to be any envelopes with ballots. You're only going to have proxies. You're going to need to look at the proxies to determine a quorum. I think it's generally fine to do that at the meeting, so long as the person looking at them is the person who's been appointed as, prior to the meeting, as long as the person doing that is the person who's been appointed as inspector. So if you hired, for example, Wilkin and Guttenplan to count your ballots and act as inspector, it would be perfectly acceptable for them to look at proxies in advance of the annual meeting to start determining if there's a quorum. But again, with the caveat that the proxy holder has to actually attend the meeting. So you can do it. It's of, I think, it may be of limited value. Okay. Now, ballots, of course, aren't going to be cast until the meeting.
All right. Okay. So one last question before we move on. You have an association that has sent a notice, had a meeting, tried to have a meeting, and did not have the quorum. Now they decide to have a meeting 3 weeks later on after that date. Does everybody have to recast a ballot? Can you utilize the ballots from the first meeting? How does that work?
Yeah, that's another good question. Proxies are generally good for 11 months. So if we're talking about proxies, they certainly can carry over to the adjourned meeting. Anyone can revoke their proxy and submit a new proxy when they like. So certainly you can reuse the proxies. If you open the meeting at the annual meeting, you had people cast ballots, it turns out you didn't have a quorum, my view is that those ballots are going to be valid as well because you're just adjourning the meeting. You're not canceling it or calling it off. So the next meeting is going to be a continuation of the same meeting.
All right. Very good. So thanks, Earle, Matt. And then we will move on to David, our next speaker. And if we have any other questions, then we'll come back to Matt later on. Now, before we move on to David, we have another polling question here. How many of you utilize an independent inspector for your election? All right, so it looks like we have about 30% who utilize an independent inspector, and we have about 70% that don't. So maybe for the ones who don't, this might help you. We're going to move on to our next speaker, David. David Schwartz is a manager at Wilkin and Guttenplan here, has been with the firm since 2006. David specializes in providing audit, tax, and consulting services for closely held businesses and real estate entities, including cooperativist corporations, condominiums, homeowner associations, and residential apartment complexes in both New Jersey and New York. For his real estate clients, he also performs agreed-upon procedures, including fraud detection, forecasting, and sponsor and management company transition reports. Prior to joining Wilkin and Guttenplan, David worked for a public accounting firm providing audit, accounting, and tax services for a diverse client base. Take it away, David.
Okay. Thank you, Mohammed. So today I'm just going to talk about the benefits of having an independent inspector, as well as what can be done to eliminate some questionable elections, as well as some helpful tips. So first we're going to talk about the benefit of an independent inspector. Independent inspectors are impartial. We have no stake in the outcome of the election. We do not own within the condominium or co-op, so to us it really doesn't matter. We're trying to do everything independently. Also, it allows confidentiality. unit owners may not want anyone else other than an independent inspector to see how the unit owners are casting their votes. Also, associations that are on a percentage interest allows confidentiality to take place because the inspector then has to calculate the percentage interest for each candidate that is running. So there's formulas that would take place in order to calculate the overall casting. Now, it also eliminates the validity of the quorum, having an independent inspector, eligibility, the voting status, and the validity of the questionable ballots. So having an independent inspector can reduce anyone that's questioning the quorum met, because in order before the election takes place, the independent inspector will calculate if the quorum is met based upon what the bylaws state. It also allows the unit owners, if based upon what the bylaws say, what the unit owner owes in assessment, the bylaws will dictate if that unit owner can vote. So if the person does owe money, and if the person does owe money, we may not be able to count that person's vote. So we'd have to take that out. And anything on the questionable ballots, typically, if there's any ballot that is questionable, we will typically consult with the attorney. And if the attorney is not present, we will use our best judgment or consult otherwise with some other inspectors as well. And also, having an independent inspector will also reduce any contentious elections. Now, here's some helpful tips. Ballots can be counted a couple different ways. You can have an independent party with unit owners, inspectors, and this is typically done on site at the election. It also can be done independent party only, so the independent party will go to a separate room and count the ballots. Or you can have the independent party count the ballots at their office, and the ballots will be mailed directly to them or through a lockbox or a ballot box. Tips to avoid some challenge elections: the ballots can be random number or coded. So what this means is that each ballot is giving a random number, and each ballot will have an identification number on it. And nobody else really knows what those identification numbers are, and it prevents any ballots from being copied. Also, having a ballot that's embossed, an embossed ballot reduces the risk of ballots being copied as well. Now, election attendees must provide, another way that's a helpful tip is having elections that the attendees must provide identification at the door. So that is the unit owner, it provides her signature, and it also counts towards quorum as well.
All right, thank you very much, David. So that's a few brief tips on how the benefit of having an independent inspector at the election and trying to avoid having contentious elections or challenges after the election. We do have one other question here for Matt at the moment. Matt, what can you do to amend poorly written bylaws that allow for a tie vote among shareholders? Bylaws that don't have a tie break provision?
Well, that would be a wild situation to have two people get the exact same number of votes. There's certainly no legal authority I've ever seen that would resolve that in any rational way. The question, though, is how do you amend your bylaws? You'd have to look at the provision of the bylaws that relate to the amendment of bylaws. That could either be an amendment by the board of directors, or it could be an amendment by the shareholders or unit owners. In condominiums, generally you require a unit owner vote. In co-ops, you sometimes see more liberality, so maybe you could do it just by the board. But I certainly would try to fix that as soon as possible if you have a situation where you may end up with a tie vote. But I've never seen a tiebreaker provision, so I don't know what would happen if that were to occur. I assume if the candidates couldn't work it out, then you would maybe have to have a runoff election or a new election, something like that.
Okay. All right, so we have another question here. What do you mean by random numbered or coded ballots? Can you share an example? So I can kind of answer that. What happens is you have computer-generated numbers that are then printed onto the ballots, and the ones that are mailed out. And so when they come back and you put the ballot or put it into the system, it then will go through those randomly generated numbers, and if it's a number that was not generated by the system, then it'll throw that out. Or it has a specific code on it, and if the code is repeated or if the number is repeated, then the system will throw that out saying that this is not a valid ballot. So these are all cases where you have really contentious elections, and you know that you're going to have challenges, and it just avoids those right from the get-go.
Yeah, and as a caveat on that, I mean, like I mentioned, the law only requires that proxies be in writing. So it may be the case that you may have to accept proxies that were not in accordance with that. What we have done at meetings where you had a real contentious issue, for example, no one wanted to sign their name to the ballot, but we needed to know who voted for who, or if there was an election. So we would have randomly numbered ballots that were matched up to a master list, and this way, the only people who would know who cast that ballot would be the attorneys or the inspector of election, and there'd be no way for anyone else to look at the ballot and know.
All right, looks like we have another question that's coming in at the moment. Just waiting for it. Okay. All right. I think I know this question. So the question here is, in terms of voting, is it typically just one vote per condo owner, or are there situations where an owner of a larger unit has more say than an owner of a smaller unit?
Yeah, well, that's subject to whatever your master deed says. I've seen both scenarios. Both are legally acceptable. The master deed says one vote per unit, then it's one vote per unit. If the master deed says it's your percentage interest, then it's your percentage interest.
Right. Absolutely. In fact, I was actually at a association where they had that, and they were trying to change the bylaws, and they had to use the percentage interest to be able to do that. Right. And actually, that leads. Matt, you had mentioned earlier about changing bylaws, and this is something that associations face such a difficulty in, because a lot of them have 75%, and to get to that 75% is not easy. Can you give any advice on what they might be able to do to get to there?
Yeah, sure. I think to get to this, if you have something like even 51% of all shareholders or all unit owners or all votes might be difficult to get to. To get that supermajority might be difficult. I think as a practical matter, the way you get it is it takes legwork by the board or by management to get people to vote for the bylaw amendment, whether it's going door to door or having the guys in the lobby hand out flyers or encourage people to vote. It will require work because, as you all know, the majority of owners are not going to be involved in the day-to-day affairs of the association and not going to want to be bothered with it, so they need to be encouraged to pass it. If you can't get a unit owner vote under any circumstance after you've tried, and I want to go back a second. There's two ways usually to change the bylaws or the master deed to get that vote. One way would be to have a meeting like you do for an election, but there's also provisions under New Jersey law to have people vote consent in writing to change. So you could, if you use the consent procedure and you're a nonprofit, you may actually be able to have it go on for a long time and have a lot of time to get people to vote. If you have a situation where there's just no way to get the approvals of the owners that you need, and if the bylaw provision was so disastrous that it prevented you from operating effectively, then maybe the way to handle it would be to go to court and seek a reformation of the document. The downside is the cost.
Yeah, wow. But that would be, I guess, a last resort sort of.
Yeah, I think so.
Yeah. All right, we have another question here. Does an announcement for candidates which lists the meeting date count as the notice time? For example, meaning within 10 days?
Well, you need to send an official notice of meeting. The the essential parts of that notice of meeting are that it's going to set forth the time, place, date of the meeting, and that it's distributed to owners in the way called for by either law or the documents, generally by regular mail. The date of mailing counts as the day of giving the notice usually. So if there's other information on there, I certainly don't think that will hurt anything. I think if you send out a notice asking for candidates 100 days in advance of the meeting and then you send out another notice, as long as the notice goes out within the statutory required time frame that has those essential elements, I think it's a good notice.
Okay. All right. All right. So I think we're going to wait maybe a minute or so just to see if there are any other questions that might come in. But otherwise, thank you, everybody, for attending. We will be sending out the survey. Please fill that in and send it back to us. We know we do a good job, but we would really like to hear from you to see how we can constantly improve. And maybe you can even suggest topics for future webinars to us. We would really look forward to that. We love having you guys on, and the whole point of this is to be able to help you run your associations and answer whatever questions you might have. So I think that's about it. Thank you very much for listening, and until next time, bye-bye. Okay, so the last question that we have here is, when will this webinar be available on the website? I would expect that it'll be there before the end of the week. All right, thanks a lot. Bye-bye.